Well, hi there, everyone. I'm David Murphy. On behalf of the whole Burbank Tech Talks team, I wanted to welcome all of you today. We have a wonderful program, really great speaker today, and just going to allow a few minutes here for everyone to connect and get settled in their virtual seats. We do look forward to, of course, welcoming you back in-person events in coming months here too. But we're so excited to gather with you today for really important topic. I mean, it's one that I learned back all the way in high school, just how important it was to have someone like our featured speaker helping you with your startup. I was just a cool high school kid, but I was on the founding team of a startup with folks around the world, and they didn't have all the IP issues and intellectual property stuff locked down, and there were all sorts of consequences. There was legal challenges with the programmer over in Australia and his, access to the intellectual property and all this stuff. And it ultimately ended up bringing down a company that the Toronto Star had called, a huge thing on the internet at the time because it wasn't, built properly. The intellectual property wasn't secured. So this is a really important topic. I mean, so so tempting just to think, oh, I can ignore this stuff. We can just focus on, building our product, getting all the basics done when you're just so busy day in and day out with all the demands of the startup. But if you don't get, things on a firm legal foundation, it can all come crashing down later. So, I just am so grateful to have all of you joining us today to hear, all these very important tips. We're lucky because, if you were to go out there and try to sit down, of course, with Laura, we all know, it does normally come with a cost, but here we have our speakers sharing all these things for free. So it's really generous, help build the community here, and just awesome. And I just want to thank the city of Burbank for making this possible. We've had so much fun collaborating since 2015 on Burbank Tech Summits and Burbank Tech Talks. And it's really all about supporting all of you, the entrepreneurial community. We do this because we want to help people. We want to have people avoid the mistakes that, that startup I was involved in as a high schooler made. Want to see others not reinvent the wheel, but really deal with all the challenges that are out there that you can manage, because it's hard enough to build a startup just on the pure gritty details of the product and the competition and everything. So it's a huge part of why I get so much excitement from doing this, just wanting to help all of you, and of course supporting the entrepreneurial community. We just been so excited to see things really take off in Burbank over the years, and it's just so much exciting stuff is happening. That's because of all of you. So, it's because of the city of Burbank, rolling out the red carpet when other cities, like San Francisco famously make it hard for startups. Here we have a city and its wonderful economic development team, actually going to all this effort to really support the entrepreneurial community. And it's great. It's not something you see a lot out there. So kudos and thank you to the city of Burbank for making this possible. And big thanks as well to the Burbank Chamber, and the wonderful leadership team. Just such a privilege to work with them as well. They're also partners in this event. And, of course, the advice today isn't just for tech startups, maybe Burbank Tech Talks. It's for, frankly, anyone out there who's an entrepreneur of any stripe. The trademark, copyright, patent stuff, licensing, all this stuff is valuable, whether you're starting an NFT startup or a new hot burger joint with really cool intellectual property matched into. So welcome to all of you, and thanks for coming, and looking forward to a great event today. So I don't want to keep you from the amazing presentation we have here. I want to turn things over shortly to Amy, but just to give you a quick background on our featured speaker, Amy Breyer. She is someone who lives in this world day in and day out, intellectual property world, contracts, trademarks, everything in between. She's been very generous with her time in the region, certainly as you can see from us, but with other pro bono projects as well. And she has been recognized as a top lawyer in the area. She's a Burbank resident. We love that. We love having Burbank speakers here at Burbank Tech Talks. And she is, very involved with everything from the Northwestern Pritzker School of Law's alumni club to SoCal Works. There's so many other groups. She is someone who has, preached the gospel of all these legal issues at conferences and legal conferences and at law schools from Yale to Northwestern to UCLA. So aren't we lucky to have you here, Amy? I should mention, of course, she is indeed a graduate of Northwestern Pritzker School of Law in Chicago. But we're glad you came out here and landed in Burbank, and here you are to share your insights here. I know how much, how valuable a lawyer's time is by the minute here, so I won't pontificate anymore. I will turn things over to you, and a big virtual welcome, Amy. Thank you so much for joining us.
Well, thank you, David, and thank you to TechFire and City of Burbank for having me. We have a lot of ground I'm going to try to cover, so let us get to it. What if there really was no way for consumers to know who you were in the marketplace? That's actually what happened to Boris Vishnevsky, who was a leading opposition candidate at a local election in St. Petersburg, Russia. I think it was last month. Putin's ruling United Russia Party actually put up two straw candidates who grew mustaches and beards and actually changed their names in order to confuse consumers or confuse voters into voting for them. And what happened? It worked. The two straws split the vote with the real Boris. All three of them lost, and Putin's candidate won. The Putin party candidate won. So it's a little bit of a dramatic example, but it shows that if you can't distinguish yourself and protect your name in the marketplace, you are not going to win. And the reason why intellectual property is so important is because it really is the heart and soul of the business. So at any rate, thank you very much for having me. We are going to talk about intellectual property basics for entrepreneurs today, and apologies, there may be a little bit of confusion. The first email blast that went out said general legal pitfalls, talking IP, and hopefully if everybody enjoys it, next session we might do one on contract basics. So looking at IP, and because there's so much ground to cover, it's really just going to be a 30,000-foot view of everything. And the idea is that it's not going to all apply to everybody who's watching, but as you hear things that make your ears perk up, you'll know that it's something you need to follow up on. All right, so basically there are four types of intellectual property. Copyright, that covers all kinds of artistic and literary works. You've got trademarks, that covers business names, slogans, product names, logos. You've got patents, that covers inventions, discoveries, useful machines and tools. And you've got trade secrets, which is kind of a catch-all category. And that can help protect probably just about anything that is a fair but a competitive advantage for you and your business. So how does this play out? Let's say you invent a widget. You would get a patent for the invention itself. You might seek a trademark for the name of your business or the name of the widget. You might look for a copyright for any TV commercials you run for the widget, for the musical jingles that you hire somebody to create for radio ads, and your customer list might become something that you could protect as a trade secret. So at any rate, let's take a look at each of these four items. And again, hopefully you just, it's going to be a lot of information, like a big information dump all at once. But when you hear something that applies to your business, I need to check into this a little bit more. So the first thing we're going to look at is copyright. The definition of a copyright is original works. It protects original works of authorship that are fixed in a tangible form of expression. What do you need? You need to have a human author. You need to have a minimum amount of creativity, and it needs to be fixed, needs to be reduced to something that people can perceive for at least a short amount of time. Okay, so what does all this mean? Human author, that's pretty self-explanatory. A minimum of creativity. There's no one standard for how minimum. If you try to copyright your rent check, that is probably not going to work. But could a bank copyright the artwork it hires somebody to put on the check face? Absolutely. Same thing with being fixed in a tangible form. It's also a kind of know it when you see it standard. You can even copyright dance choreography. You just have to be able to either videotape it or you write it down with explanatory notes. Anything that can be perceived by the examiner's office, either by their eyes or ears, or whatever. It's a pretty low bar. It is definitely the lowest bar of any form of intellectual property protection. So what can be copyrighted? The categories you see on the screen there are the traditional categories. And as new types of creative works are developed, they simply get kind of slid into existing categories. So for example, you can copyright computer code, and typically you would just do it under literary works. There are some exceptions to that, but that's where it generally would go. What falls outside of the scope of what you can protect? Well, things that don't meet the three-pronged definition we first looked at. Like, for example, can you copyright your grocery list? No, it's not going to meet the minimum creativity level. Other things can be very creative. I think I see something in the chat box. I think what we'll do probably is let me try to just run through as much as I can, and we're going to have some time for questions at the end. Things can be very creative, but if they don't fall within the scope of copyright protection because they fall within the scope of something like trademark or patent protection, you just need to look at those other laws in order to get your ideas protected. Generally, the most common expression in the world of copyright is people say you can't copyright ideas, only the expression of those ideas. All right. So how does this apply to you? Well, if you're advertising any of your services, if you have an instruction manual that goes with your products, if you have a website, if you have photos that you've taken to put up on your website, all of these things are potentially subject to copyright. Now, is it going to be worth your time and money to copyright everything? Probably not. But if you don't copyright something, it should be because you have thought about it and made the affirmative choice. It's not worth it to your business, not because you didn't even think to do it. All right, so let's drill down to what the exact differences are between the amount of rights federal law gives you just by virtue of having created something and the extra rights you get when you go through the time and trouble to register your works. So without doing anything other than basically, so to speak, putting pen to paper, you get a certain amount of like a basic bundle of rights. All right, not every right is going to apply to every single thing. Like, for example, it doesn't make any sense to talk about displaying your symphony. But if you take something like a film, for example, well, you can make as many copies of your film as you want without ever getting a federal copyright registration. You can make derivatives. That means things like sequels or anniversary editions. You can distribute, you can run the film, you can display single images as ads in the lobby, or you can license it so somebody else can do any or all of those things. On top of that basic bundle of rights, you get a little bit more protection if you display the copyright. You're not required to display your copyright since I think 1989, but if you do it, and as everybody, you're familiar with the symbol, it's the little C, you need the year, you need your business name. If you choose to display the copyright, it's still, you get the little added protection because it puts the whole world on notice that you are claiming a copyright in your work. And it makes it easier for parties who are seeking permission to work with you to find you. It makes it harder for people who try to cheat you to use something called an innocent infringement defense if you actually took them to court. And it helps calculate the terms for things that might otherwise be hard to figure out for anonymous works or pseudonymous, I can never pronounce that works. That's when you use a pen name or works for hire. It also helps prevent, and this gets a little bit wonky, something called Orphan Works, which is works that people are trying to find the owner to get permission to use, but they can't because they can't figure out who it is. The Copyright Office doesn't. The copyright law does not like orphan works. I want to take a moment to pause also. If there's anybody watching today who is like a writer type and has scripts registered with the WGA script registry, or basically if you register your creative works with any other sort of registry, that's all well and good, but you don't get the federal copyright protection. There are certain things that you get with federal copyright registration, and only federal copyright registration. Those benefits are that it establishes the best possible public record of your claim. It's the biggest database nationwide. You need that registration in order to file an infringement suit. Even if you apply and you get turned down, the mere fact of the refusal is still a valid basis upon which you can file your infringement claim. You can use it as what's called prima facie evidence in a lawsuit. That's on its face, it establishes that you have both the copyright and the facts in the certificate that make up the copyright. You can, at that point, if you're registered, you can ask U.S. Border Control to work with you to help keep out infringing goods, which is a huge plus. And it opens up the possibility of getting statutory damages, costs, and attorney fees if you bring a lawsuit. The big thing to keep in mind, there is a really specific window. You need to register your work either before the infringement occurs or within 3 months after the work is published. I realize this is throwing a lot of stuff at you. If you want to get a copy of the slides, I'll give them to David. So don't worry about like furiously taking notes or anything, because it's on the slides. Okay, so anyway, what are statutory damages, or how much are the statutory is worth? Typically in a copyright case, the average range is from $750 to $30,000 per work. It can be as low as $200 for innocent infringements, but it can be, drum roll please, as high as $150,000 per infringed work. So it can actually be a really useful tool, real sledgehammer in order to try to keep infringers from cutting in on your turf. There's other things you can do with a copyright. You can transfer it, sell it, bequest it. Those are things that tend to occur later in the life of the business. And because today's talk is geared more towards startups and younger businesses, I'm not going to go into detail on that now, but you should know that someday down the road, if you wanted to do any of those things, you could. All right, so next question. How do you apply for federal copyright registration? Okay, so now we get into the nuts and bolts. You have your application, you have got what's called a deposit copy, and you have got your non-refundable filing fee. So the application's got the basic facts of the claim. It's like the name of the author, the name of the work, the name of the copyright holder, if it's a work for hire, so that's a different person or entity, whether the work has been previously registered, published, or registered, like if it's another edition. Anyway, you've got these basic facts about the work. Again, depending upon what it is you're trying to register, there's a lot of detail here, and I don't want to get too bogged down on any one thing. If you've got specific questions about this, we can come back to it. Deposit copy is, deposit here is a term of art. It does not mean the money that you pay to file. It literally means the thing you give the Library of Congress to prove that you've actually got the work. It is typically the best edition they want is 2 copies of whatever it is, but again, that's just a general rule of thumb. It's not always 2 copies. If you're registering a copyright in a sculpture, you're not going to send them 2 copies of the sculpture. You send them a description and a picture. If certain types of things like unpublished works, you only need to send 1 copy. There's an FAQ section. If you're actually going to register a copyright and you want to try to do it yourself, there are very specific FAQs that will walk you through exactly what you need. There's a lot of ins and outs. So, if you only need to send 1 copy because it's unpublished work and you send 2, it's not a big deal. But if you're sending in a book or a screenplay and you're supposed to send 2 copies and you only send 1, it could be a big deal, because if it holds up your registration and you're trying to potentially deal with infringers, you don't want anything holding up your registration. And then the filing fee, again, it depends upon exactly how much you're trying to file, but typically it's less than $100. All right, so you would go to copyright.gov if you want to file online. There's a form there. You can also get onto the website and download forms if you wanted a paper file. Once you get on the website, you're going to see, this is if you scroll about halfway through the screen, there's a bunch of different boxes you can click on. The one for registering your works is kind of in the middle here. That takes you to a portal, which looks like this. And you need to sign up for a free account, totally free, but that's just how they do it, is you need an account. You click on this blue box, it takes you to the form you need, you fill it out, and send in your deposit copies and your money, and you're good to go. All right, so I'm running too slow on time. So the next, that's how you copyright, that's what you can copyright. So the next important consideration is who can own a copyright. All right, and there's several different forms of ownership. There are single authors, and the term of the copyright, if you're a single author, is the life of the author plus 70 years. You also have what's called joint authors, where the intent is to merge everything into one work. That's like, for example, a screenplay or a film where you've got the cinematographer, you've got the directors, you've got the actors, you're making it all into one work. You've got multiple author situations where the intent is to contribute to a collective, like, for example, like a book of poems would be a collective work. And then you've got work for hire. There are some landmines associated with all of these things. And I know, again, it's a lot of information in a really big dump. Joint authors, the thing you really need to look out for is that any individual author could contract away their portion of rights for, you know, their interest in the copyright. And then if you're working with other people and one person goes rogue, it can have some serious implications for the other folks in the group. Work for hire has different kinds of landmines. There's only two specific situations where it occurs. One is as an employee as a part of their regular duties, and the other is when you have an express written agreement, except it has to be before the work is created. That's really important. So at any rate, and the term of copyright for joint authors is 70 years after the death of the last surviving author, and for works for hire, it is 95 years from date from the authorship, or 120 years from publication, whichever is shorter. At any rate, again, big information dump. Go check the website, you'll see what it is that exactly applies to you. So you'll start to be able to calculate and know what your rights are and what you need to keep in mind. So of course, the big question is, can you do this yourself? And I wouldn't be a good lawyer if I gave any other answer than it depends. If it's a basic copyright, if it's like one photo or, you know, one whatever, and you want to, you know, you read the tutorials and you feel comfortable, go for it. If I was going to DIY anything in intellectual property, it would be a copyright. But if you are, you know, if you've got a lot of moving parts to something, if you, for example, are reading through the basics circular from the copyright department and the copyright office, and it doesn't answer your question, it probably means you don't have a basic question. And it may be something where even for getting a copyright for your work, you may want to look for help. All right, so moving along, let's talk about trademarks for a moment. How is trademark defined? Trademark is defined as any word, phrase, symbol, or a combination of these things that identifies your goods or services. Trademark technically refers to goods, and service mark technically refers to services, but service marks are a subset of trademark. It's okay if you refer to everything just as a trademark. And yes, trademark is one word, service mark, 2 words. All right, so that is what a trademark is. What is not a trademark? This is really important. Your domain name, not a trademark. A trademark is a brand. And it's not enough to just purchase your domain and think that you are protected trademark-wise. You're not. When you go to pick a name for your business, you have to, one, make sure that the domain is available that you want, but you also have to check something that's the general trademark office database to make sure it's available in their database. And we're going to take a look at that in a minute and how you can run that search. Excuse me. All right. So a key concept in trademark is that a brand means a source identifier. It's how customers can find you in the marketplace and trust that they are buying your goods and services as opposed to somebody else's goods and services. So like, for example, the reason when you see a blue box of a certain sort and you know it's Tiffany, it's because they've trademarked that color. A trademark can be not just a word or a phrase like we're all used to, but it can be something like a color, like the red soles of Louboutin shoes. And it can even be something like a sound. Because for example, if I say, and forgive me here, ah, 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 right? That's NBC because they've trademarked that sound. Nobody else can run that sound with their programming. Again, you can trademark business names, product service names, slogans, logos. But what can't you trademark? Well, in addition to the fact you can't trademark things that are would fall under copyright protection or patent protection, generally in the universe of trademark, what they do is describe it in terms of the characteristics of things that, types of things that are not trademarkable. And I'm going to show them here so you can just kind of take a look at this list. We're not going to have time to discuss all of these in detail, but for example, if you want to name your ice cream shop, you can do that. You can name your business whatever you want, but the trademark office is not going to register that for you and then block everybody else or let you block everybody else from using the words ice cream shop to describe their ice cream shop. Likewise, you can't call yourself City of Burbank Ice Cream Shop unless the City of Burbank is actually the one running the ice cream shop. One area of law that's kind of in the middle of changing is immoral or scandalous names that used to not be allowed at all. There was a big case on that recently, but unless you want to pick a name that's racier than FUCT for your brand, don't worry about it. Just color inside the lines. You'll be fine. One area where business owners do tend to get a little tripped up is the tension between trademark law and marketing. And in a marketing universe, the most important thing is you want to have establish the quickest, cleanest, easiest connection between your product, your brand, and what it is your goods and services do, right? So you want to go for something quick and snappy. The trademark law actually rewards the opposite. It rewards businesses that take the time and spend the money to build up a name for themselves that makes that connection in consumers' minds. So in terms of things to avoid, if you try to just misspell a word to be cute, which is very common, you're probably not the first person to think of it. You'll probably have a hard time trademarking it because it's been done already. You don't want to just describe what you're doing, you know, world's best hot dogs. Again, it's the easiest thing from a marketing perspective, worst thing from a trademark perspective. The trademark office has a very, very Byzantine system for how it evaluates what it calls the strength of a trademark. And it starts with generic, like the ice cream shop example. You are never going to get a trademark for that because it's simply, the name is what the good or service is. Next up is merely descriptive. And so say, for example, you have an ice cream shop and you want to name it Cold and Creamy. It's a little better than calling it ice cream shop, but you're still not going to be able to get a description, get a trademark in it because it really is just describing what your product does. It is possible with a descriptive mark to get it onto the Supplemental Register. We're going to talk about that in a moment. But what you are better off doing is picking a name that is at least suggestive by trademark office standards. Something like Netflix, for example, it doesn't say, it's not named streaming service you watch at home, but the term Netflix is suggestive of what the business does. And likewise for products, something like naming a car Jaguar or naming a truck Ram, it doesn't exactly say this car is fast or this truck is strong, but that's the suggestion, the implication by the name. The next category is something called arbitrary. And that's when you take a word that already exists, but you use it in a totally different context. So if you have something like, for example, Apple computers or Dove soap, those were words that existed before those companies did, but you never thought about them in relation to computers or soap until those companies took the time and spent the money to make that connection about their brand in consumers' minds. The strongest category of trademark protection is something called fanciful, and that is when you make up words. So for example, Exelon, Rolex, Google. It's the hardest thing to start with because you look at that and you go, well, what is a Rolex? But once the company takes the time, makes the marketing effort to make that connection, should you end up in a trademark battle in some courtroom somewhere someday, that is the kind of thing that courts look most favorably on, where you will be accorded the strongest trademark protection of all. All right. Moving right along. Okay, so like copyright, trademark law automatically gives a certain small bundle of rights just by using your mark in commerce. And that is typically that you can use any name you want and just start, just open up a shop and go do it. But your right to your name is limited to your actual geographic area of business. So if you open a pizza shop and you call it, Pies R Us, and somebody else next door opens up a pizza shop and calls it themselves Pies R Us, you can take them to court and you can get them to stop using Pies R Us as long as they're next door to you. If they're 2 states over, not going to happen. Now, that concept, of course, has gotten a little bit muddied since the advent of the internet, but don't think because you have a website, you have global protection, because that does not work that way. Again, like copyright, you don't need to use your trademark symbol, but there are some benefits of added benefits on top of your basic rights from doing that. It's a little bit different looking than copyright. You don't need a year, you don't need your business name. You just need whatever the brand is you're trying to protect. The TM is for common law copyrights that anybody you open a store, as soon as you do, you can slap the TM on your brand name. The R in a circle is once you're registered. It's good for both supplemental or principal registers. And that's how people know that you've got copyright protection. Again, benefits of doing this, it puts potential users on better notice, just like if you use it for copyright purposes. Makes it easier for people who actually want to play nice and work with you to license your goods or services to find you. Makes it harder for potential infringers to wreak havoc. So now that's what you get by just opening up a store, that the law says you get these certain basic things. If you register for a copyright with the trademark office, you get these extra benefits, which make it a lot more worthwhile. Again, puts you on the best possible notice. Again, it's prima facie evidence that you own the mark. It helps you to secure trademarks in other countries. It's not sufficient. Once you have a US trademark, it's not like you automatically got your trademark in Canada, but it is like a first step to making that process for other countries easier. Again, you can ask Border Control to work with you to help keep out infringing goods. And again, it opens up the possibility of statutory costs and attorney fees. So what are we looking at here? And just a quick, in case you're not familiar, actual damages are when you've actually lost money. And in instances where somebody is infringing on you, but you haven't actually lost anything yet, it's the statutories, the stuff where there are amounts that are written into law that you can fall back on. And sometimes these even exceed what your actual damages are anyway, even if you have actual damages. In a trademark context, damages vary from 1,000 to 200,000 for per counterfeit mark, per class of goods, whether they're actually sold or even just offered for sale or distributed. But they can range as high as $2 million per mark, per class. So it can, again, be a huge sledgehammer to try to get potential infringers from invading your marketplace turf. All right. How do you apply for federal trademark registration? Again, another dump here. You have an application. You've got what's called a specimen instead of a deposit copy, and you've got your non-refundable filing fee. Where do you go do this? Before you actually even go to register for fill out your application for a trademark, what you need to do is search the main database to make sure your name isn't already there. This is really not for the faint of heart. I'm going to describe it briefly. If you are looking to use a completely made up word that you've made up yourself for a business that is already up and running, that is the most basic kind of trademark application, and you may feel comfortable doing it yourself. If that is not your situation, this is probably a good place to take a bathroom break. It gets pretty obscure. At any rate, so the first thing you need to do to properly figure out if you can register your trademark is to search what's called the TESS database, and TESS, I believe, is Trademark Electronic Search System, something like that. If you look at this little box, this is what the screen looks like when you click on that link, and then you click on this little box here. It takes you to 3 options. Your most basic option is the word mark search. You put in your made up word, and if it doesn't return any results, you know that you're good to go. You can use that first box to put in words that exist if you want to say Pies R Us as your name. But the problem with that first box is it only returns exactly those words in that order. And the trademark examiner, when they examine your application, are going to be looking for things like misspellings and whether part of the word shows up in a bigger string of words. At any rate, the examiner uses this third box down here, the freeform box. And so, for example, let's say you had a book press. You want to call your book press Bookworms. You can input bookworms in that first box, the word search box, and all it's going to return is that. But the examiner, in trying to figure out if they're going to give you a trademark or not, is going to look for all these variations on the spelling. And they're going to use that freeform box, that third box, and the search string for something like that actually ends up looking more like this, right? So if your eyes are glazing over, that is a normal human response. And it's probably also a signal that, this is something you may want to get some help with for this part of the process. But assuming that you have a made up word, you're good to go. There's no search results. Just very briefly, you would log on here. It takes you to a page that looks like this. Again, like the copyrights, you need to set up a free account in order to file your application. Once you set up your free account, it takes you to a page that looks like this. This is your trademark application. It is literally about 30 pages that all look like this. You don't, depending upon what it is you're filing for, you don't need to fill out all 30 pages, but it's layers, so it covers every circumstance. It is going to ask you a lot of other questions. We're not going to have time to go into what each and every of these things mean, but for example, it's going to ask you whether you want to register just a word or a design. Filing basis has to do with whether your mark is currently in use, or you intend to use the mark, or it's currently in use but in another country. It's going to ask you to define which classes of goods and services, and what that means is they've got a very specific nomenclature, like clothing is in one class of goods, and sporting equipment is in a different class of goods, and so forth. It's going to ask you whether you want to do collective or certification mark. Those are different types of trademarks. So like a collective mark, for example, is something like AAA, where all the tow trucks display the same AAA symbol. That's because they're all members of this collective. Certification mark is, it signifies the qualities of something that every member of the group has. So like, for example, when you go into a building that's got a LEED certified plaque on it, LEED certification is a type of certification mark. It's going to ask you if you want to file an application for trade dress. That's another type of trademark. Like, for example, the maker's mark bottle of whiskey, where it's got the red dripping wax. There's a reason why every other bottle of whiskey or beer or wine doesn't do that. It's because maker's mark has that trademark. That's something called trade dress for packaging. Who can own a trademark? It's a little bit different than copyright situations. You can have one or more individuals or businesses. They're not called authors, of course, it's just the owners. There's no collective work equivalent. Like, you can't have a logo with words and have one person own a portion, the word portion, and the other person own the logo portion. You can have multiples owning the whole together, or you can have multiple marks and each own something different, but you can't do that collective equivalent. If you cannot get yourself onto the principal register, there's something called the Supplemental Register, which is like Principal Light. It's basically for descriptive marks. If you go on there for a certain period of years, and then you can do what's called proving acquired distinctiveness, You can get yourself moved up to the principal register. There are still some benefits of being on the supplemental. You still get the notice value. You still get to use that registered symbol. You get to prevent other people from later filing marks that would be confusingly similar to your mark. And you still get the opportunity to file your trademark infringement suits in court. So you still get a lot of the same advantages. Big thing for business owners to keep in mind with trademark, it is a real use it or lose it proposition. If you are not actively using your mark in commerce, it is subject to attack and you can lose it. And there's all kinds of things you would need to do to either prevent that or get yourself back on the register if that happens. It is also a defend it or lose it proposition, because if you become aware of potential infringers or actual infringers and you don't do anything about it, again, they could wrangle the mark away from you. There are mechanisms for doing that. So if you find somebody who's infringing, it is important to take steps and to document, to show a court, if it comes to it, you sent a cease and desist letter, you filed a lawsuit, you asked customs to help stop bringing their goods into the country, whatever it might be. Another really quirky thing about trademark is if it becomes overused, you could still lose it as well. This is extra wonky, even for trademark, but follow me here. You have to be really careful about how the consuming public perceives your brand, because your brand is supposed to identify only your goods and services. So if you have a situation, for example, where everybody starts calling every product in your category by your brand name, that's not, it's a big compliment, but it's a disaster for trademark purposes. The Otis company used to call its product and only its product by a certain name. It made a moving staircase, but soon everybody was calling every moving staircase they were on an escalator, regardless of who manufactured the moving staircase. And the Otis company actually lost its trademark in the word escalator because it became generic. That's something that the trademark world calls genericide. A lot of companies have dealt with genericide. Aspirin became a generic in the US. Google right now is at risk of losing its trademark and becoming generic. When you think about, everybody talks about running a Google search, even if they're using Firefox or Edge, even if they're within a database, like they're on Facebook and they want to, look up a particular event, and you say, I'm going to Google it on Facebook. Not really. So that's the risk of genericide. You want to always make sure to set up your advertising so customers are referring only to your brand by your brand name, and to the product of whatever it is separately by whatever the product name is. All right. So let's see. Sure. Again, do you want to do this on your own? There's a lot here. It may be worth it to you. It may be something that you want to hire out for. Those are some of the main considerations to keep in mind. I'm going to do very quick definitions, a very, very quick look at these other categories and try to save some time for questions. I don't do patent work. And so full disclaimer up front. The definition for patents, one thing you will see is that patent rights are set up differently than trademark or copyright rights. Instead of having the right to do something, what a patent is the right to exclude others from doing your thing. There are three types of patents. There are utility patents, which are for new and useful inventions. There are design patents that have to do with designs. There are plant patents that have to do with developing new species of asexually reproducing plants. All right, if any of this sounds remotely familiar or remotely like anything that any of your business revolves around, my one and only piece of advice is get a lawyer. Patent work can be extremely complex. Again, I don't do it, but if you want to reach out, I can try to connect you with somebody that has expertise in the particular area of patent law that you need. All right, taking a quick look at trade secrets. That's our fourth area of intellectual property. Here is the definition from the California Code of what a trade secret. As you can see, it is a lot of words, but in plain English, trade secret can basically be anything that is worth money to your business because nobody else has access to it, and that you actually try to keep it a secret. So for example, you can have things like customer lists, your sales figures, your marketing projections, McDonald's French fry recipe, Google's search algorithm. All of these things have value to the company. And so it's something that they do try to keep secret. Sometimes there is some overlap, like for example, yes, you can copyright computer code. You are allowed to redact certain portions of your code if you consider it proprietary, and those portions of redacted code could qualify as a trade secret. Most of the time, everything in a copyright or a trademark or a patent, it's a matter of public record. So for the most part, trade secrets cover different territory, but there can sometimes be a little bit of overlap. And how long does a trade secret last? It lasts for as long as you actually try to maintain it as a trade secret. So in theory, it could last for the entire life of your business. All right, taking a quick look at some other concepts in IP that you might run into beyond the basic 4 categories of copyright, trademark, patent, and trade secret. Speaking now to the computer folks, to the software folks in the room, and I know I have a lot of clients who are very big on open source and feel very strongly about it. But just because you believe in open source, don't think that it means that you cannot avail yourself of various forms of IP protection. Open source is not the same thing as no IP protection at all. You can definitely still register your trademark. You can license your brand to other developers. And so you get the benefit of still being able to have a source identifier to say, this is what our brand means. You can put restrictions on the license, and you can say, for example, if you want to use our brand, you can't make any modifications to the software, or you can only make certain modifications to the software. So, I mean, note the curves on this, right? You can have a developer, you can have open source software, and you can have a developer fork your project, or they can make something totally different for that matter. But if they want to do something totally different, they just have to market and brand it under a separate name. So anybody who sees your brand still knows what your stuff is. You've got other concepts. Another big concept in intellectual property is something called fair use. There's a huge body of case law in fair use. I'm just going to very briefly, it's a 4-pronged analysis. I'm not going to go into the details, but just to hit the highlights, some people think, okay, I'm using it for educational purposes, so I can do whatever I want. That is not the case. Just because it's educational does not necessarily mean that you can use somebody else's work for free. There are still parameters to that. Don't think like, oh, I'm just only using a little of it, so that's fine. Sometimes a little of it is okay, but sometimes a court could still find that even just the little is the heart of the work. If you're using the piece that you're borrowing, you need to transform it somehow. So it's making some other sort of statement. If you take whatever it is and you're using it in exactly the same way as the original creator meant for it to be, that's not going to be considered transformative. It's probably not going to be considered fair use. And then the last factor to keep in mind is if you are making money off of whatever it is you're borrowing in any sort of way without paying for it, that is probably not going to be okay. Another concept that is very big in intellectual property is something called moral rights. It is originally a European concept called droit moral. It did not used to be part of American law at all. That changed, I think it was 1991 with VARA. But basically for moral rights, it's the right of attribution, that you can claim that something is yours, the right to be able to publish works anonymously or pseudonymously, and a right called the right of integrity, which is the right to keep something from being done that you feel destroys the work or harms your reputation as a creator. Those droit moral rights were written into something called the Visual Artists' Rights Act. Does not protect every type of creative work. I think it only protects certain visual works, and there are certain limitations on how many copies, and they have to be signed whatever the other criteria are. But if you fall within that category, it actually provides some really good protection. There's plenty of other acts that impact, or other laws that impact intellectual property, like for example, the Digital Millennium Copyright Act. We could spend an hour on any of these things, which we don't have time for now, but the point being is it is a really vast area of law. And so if you take away nothing else from today's talk, other than I tried to cram too much into 1 hour, what you should take away is just take a look at all of these different areas of your business, so you can kind of develop some plans and say, this is worth protecting, this could be, but I don't need it. So again, if anybody wants a copy of the slides, I can give them to David, and I've got some information, some general resources. The stuff I pulled here is just from the federal government resources. There are lots of resources out on the internet. You just want to be careful if you're pulling something from a private law firm or from some other source. Take everything with a grain of salt, because you never know. Some materials are great, others are terrible. People have got YouTube videos out now on how to file a trademark application. It's all kinds of things out there. So here's just some resources for general information, some DIY tutorials for filing your own application. There are tons of webinars that the Copyright Office, as well as the Trademark and Patent Office, offer in order to learn more. Some other materials if you want to read, if you've got nothing else to do with yourself. One thing I do want to call to your attention, if you think that you may have something you want to patent and you're not in a position to hire an attorney, the Patent Office actually has a pro bono program. If you meet their income requirements and some other requirements, you may be able to actually get legal help through their pro bono office. That's about it. And there's David. Okay, so thanks. And hopefully I've left a few minutes for questions here.
Amy, this has been fantastic. In fact, we just had a comment come in the chat saying, great presentation. I wholeheartedly agree. And if we were in the room live, we'd all be applauding madly right now. That was great. This may not be trade secret stuff here, but it might as well be secret sauce to a lot of us. Super helpful. And I think hopefully we'll save folks a lot of grief. I just wondered, I want to jump into questions here. We can get through rapid fire as many as we can. We have a lot of great questions. I'm really impressed. One of the best, most provocative presentations we've had in a while in terms of engagement here with Q&A. So just rapid fire style. This one you'll like. One of our first questions. What are some of the key questions when shopping around for an attorney, and how do you discuss things like rates and all that tactfully?
Sure. Well, typically most attorneys don't advertise their rates online because there's a long history of attorneys actually being ethically barred from doing that, and then a long culture that developed of it being considered unseemly. So it can be a little frustrating because it's obviously a lot easier. I know when I go shopping, like if I pick up a shirt I like, I will look at the price tag as part of my consideration of, is it worth it to me to buy this shirt? But as you're shopping around, if you don't see prices online, and you probably won't, it's okay to just ask. People would rather you be honest with them, because the worst thing you can do is to say to somebody, what's this going to cost? And they say X, whatever it is. And it turned out that you really can't afford X, but you can afford half X, and you pay halfway through, and you get halfway through, and it's like, I can't. Like, why do that to yourself? Why do that to somebody else? So you just, whatever it is you need, you say, okay, I think I need X, Y, Z. Let me explain to you what the situation is, because it's also possible you don't even know what you need. And if you explain the situation, hopefully somebody can give you some advice on what it is you actually need. And then you say, what do you charge? What do you charge? And frequently the answer is still going to be, it depends, but they should be able to give you a range. Like, for example, I'll do a trademark application on a flat rate because I've done them before, and I know on average how long it takes me to get the job done. But if there's litigation down the road, there's, for example, something called TTAB, which is the Trial Appeals Board. If you have to Or even if you go to file your application and the trademark office comes back with a refusal, there's this thing called an office action, where then you first have to respond. That kind of stuff I'll do on an hourly rate, because I can't predict how long it's going to take. But the engagement letter says, here's what you get for X amount of money for certain services, and then here's the rate for the hourly services. So.
And someone said, why does it cost $30,000 to get a patent or more?
Okay, again, I don't do patent work, so I'm not a good person to answer that question. My guess is because it's incredibly complex and time consuming. Like if you remember that one search string that I showed for what a free-form search looks like in a database for trademarks, that is exponentially simpler than what patent work looks like. But again, you should be able, if you're thinking about hiring a patent attorney, you ask them, well, how long do you think this is going to take? What do you do? You know, tell me what it is you're doing for that. Yeah. And
we also have a couple of questions relating to logos and such. We have a question saying, what if you create a logo with variations? Each variation is going to be used in a different context. Do you need to copyright the main logo only? You have to copyright everything separately. It get really costly.
Okay, well, first of all, copyright's your least expensive protection. So, you know, if you're looking like $50 a pop, that's nothing compared to what some of the other fees are. The general rule of thumb is you do not need to put a fresh copyright in for minor changes. But if there's a big change, you would want to put a fresh copyright in. So what's minor? Again, there's no one standard. But if you have a logo that, you know, has 5 flowers in it and your new logo has 6 flowers in it, you probably don't need to change it. But if you have a logo that's a blue square and then your next logo is a red circle, then you do need to get a fresh copyright. When you do a trademark, it's a similar kind of standard. If you trademark just the words of your name, like for example, let's say you had a business called Community Development. If you trademark just the words, it's called a word mark, and then it blocks anybody else from having the same business doing the same kind of goods and services using the same name, Community Development, no matter what the logo looks like. If you submit the entire logo to get trademarked, you can certainly do a design logo, but then the only thing that's protected is that logo. You can specify whether you're claiming color as part of a mark. So if you don't claim color, you submit it in black and white, it would be good for any kind of color. There's strategies. Normally you would want to go as broad as possible, but if somebody has something registered already that's very similar and you are so in love with your name, you can't bear to change your name, one way of potentially getting around it is by looking to register something as narrow as possible. So you kind of get what you want, but it's going to be much weaker form of protection.
And we're running short on time, but I did seed the chat with a question I want to ask you. I'm going to jump in. What are the biggest controversies and trends right now in the world of intellectual property law for businesses? What do you and your colleagues see out there at the legal conferences?
Well, you know, I mean, it depends, because obviously things that go on in each of these universes is totally different. I mean, there was a really big suit between Google and Oracle that, you know, had ripples throughout the copyright world earlier this year. It doesn't really matter if what you do is trademark. I mean, right now, from a trademark perspective, actually, one of the most annoying things is there's been such an influx of people starting businesses during the pandemic and trying to register their trademarks. It used to be that you could submit an application and you could have an examiner assigned to it and get your mark registered in like 3 months. It's easily double that now. I mean, this is not a sexy issue at all. But something that used to take 3 months is now, you can go 6 months and not even hear back from the trademark office. So that's like, from a real practical standpoint, particularly if you may be dealing with a potential infringer or an actual infringer, it could be really frustrating.
Just like getting a passport. Gosh.
Yes.
And are lawyers overloaded in IP? Like you hear some sectors, there's so many startups that lawyers just can't handle it all. Is that happening with IP?
You know, it depends. I'm sorry, every answer, it depends.
Yeah.
Sure. There are certainly, there's growth in some areas where people will dive in. Like right now, NFTs can be really hot. It remains to be seen if it sticks. it's not intellectual property, but like cannabis law is really big. As you know, it was completely illegal 10 years ago, or 15, whatever it was. And now as it becomes more legal in more states, those businesses are absolutely booming. So if you're looking for an area of law to go into, if you're like a law student out there thinking about it, maybe something like cannabis. Crypto, similar thing. Yeah.
Well, you know, we could jump into a lot more questions here. We are out of time. I see more I wanted to get to. We'll have to send out certainly the deck, which was super helpful to everyone, including that link to the resource you mentioned. Folks can go to for more sessions coming up. But we'll have to have you back, Amy, sometime to get into all the contract side of things. This was a fantastic, very insightful presentation. Really appreciate your service to the tech community here. And again, deepest thanks to the city of Burbank, to Simone, Mary, Marissa, Megan, everyone there for making this event possible. I think they get the credit for connecting me and you, Amy. So thank you, Marissa, in particular.
Yes, thanks, Marissa.
You know, this was one of my favorites in a while. Really enjoyed it. I know everyone, judging by the Q&A, really was engaged too. So I really appreciate it. And we'll get that slide deck sent out to everyone. So thanks so much, as well as the Burbank Chamber for partnering here. I hope all of your members found this as useful as the tech folks did. And of course, the tech community should be members of the Burbank Chamber too. We want to make sure, you know, sometimes in Silicon Valley, tech companies are in their own siloed world. We want to have active civic engagement with all the you know, wonderful organizations out there like the Burbank Chamber. So if you're a startup, haven't joined the chamber, do that too. So anyway, thank you so much, all, and most of all to all of you who've joined us. Rooting for you. It's been a crazy couple of years through the pandemic. You're all doing great here. Rooting for you to keep expanding and keep making Burbank an awesome entrepreneurial community. So thanks again, and thanks again, Amy, and see you all in the next one. Bye-bye.
Bye.